My name's Andrew Moon. I'm the head of brand and corporate communications here at Transcend, and we're thrilled to have you here for what we're calling our Texas Privacy Roundup, co-hosted by Transcend, the next-gen privacy and AI governance platform, and the Future of Privacy Forum. Before I hand over to Ron DeJesus, some quick housekeeping and some notes before we get started. If you're not familiar with Transcend, we help companies reimagine the impact privacy can drive to their business. With our privacy and AI governance platform, we'll help companies transform how they understand and manage personal data, automate privacy tasks, assess risks, and oversee AI systems to unlock new value from their customer data. And I suspect everyone on this call is familiar with the Future of Privacy Forum too, but I wanted to give special mention to the incredible resources Keir and the various teams put together as part of their membership program in service of us all staying on top of this patchwork of privacy laws in the US and building great privacy programs inside our organizations. So with that, I'm going to hand it off to our moderator for today's conversation, Transcend's Field Chief Privacy Officer, Ron DeJesus.
Thanks, Andrew. Everyone, welcome to today's session. I'm Ron DeJesus, Field Chief Privacy Officer at Transcend. I'm unfortunately not wearing my cowboy hat today. I am saving it for the Cowboy Carter tour that's coming up, but I do actually own one, but not for today. But I'm actually really looking forward to this conversation. It's not every day you get to sit down with two people that are making an incredible impact in our industry. And it's not every day that we get both of them here today. So yeah, I'm just really excited that we get to hear from what a US state AG is doing specifically, and then also get that broader state perspective. So personally, I think this is going to be a really, really interesting discussion. I'm looking forward to your questions as well. So we've got Tyler Bridegan, Director of Policy and Technology at the Texas Attorney General's Office, and we're also joined by the wonderful Keir Lamont, Senior Director of U.S. Legislation at the Future of Privacy Forum. I'm going to pass it on to each of you guys to just get a little bit deeper in terms of your role and what you bring to the table here for this session. But Keir, let's kick it off with you.
Sure. Thanks so much for that introduction. I'm really happy to be here. As you mentioned, I work at the Future of Privacy Forum, though in my role, it often feels a bit more like the Today of Privacy Forum. And my role is very much trying to run around, follow what is happening in terms of consumer privacy on the Hill, at the agencies, and increasingly in the states, trying to make sense of new privacy bills, new regulations, and increasingly new enforcement actions, and distill what is meaningful about these developments for the broader stakeholder community in this wonderful privacy space.
Thanks, Karen. I obviously love your fortnightly state privacy patchwork, the patchwork dispatch, right?
Yeah,
I look for that every fortnight. That's 2 weeks, right?
yes, it is.
Yes. Okay, cool. But yeah, I really am looking forward to your state by state color here. And Tyler Bridegan, thank you again so much for joining us as well. I know you're incredibly busy at the AG, at the Texas State AG's office. But Tyler, could you just give me a sense of a little bit of a deeper dive into your role at the office, and then also kind of where you sit within the consumer protection agency there?
Yeah. And Ron, is that your actual kitchen? Because if so, I'm kind of
It is. I love it. Yeah, it's super open concept, but yeah, not fake at all.
beautiful. Nice. Well, yes, my name is Tyler Bridegan. I am the Director of Privacy and Tech Enforcement for the Texas Attorney General's Office. We are housed within sort of the broader Consumer Protection Division of the AG's office. Came over about a year ago from private practice. Our sort of mandate is really, as the Texas legislature has passed a series of privacy and tech-related laws, to really enforce those, look into what practices are going on across industries, and be responsive, as new issues sort of emerge. I should also add the standard disclaimer that I naturally forgot at the beginning, that anything discussed here are my own opinions and not necessarily the opinions of the Texas Attorney General or its office. But yeah, so we are a team of about 20 personnel made up of attorneys, privacy analysts, technologists, and support staff. I am personally located in Houston. We have team members in pretty much every major Texas city, Dallas, San Antonio, Austin, and Houston. So we do a lot of cross-office collaboration. I think probably similar to Keir, it's also a bit of a fire hose. There's always something, either a new law is being contemplated, we're trying to enforce on a new technology or look into it. Some breach happens, but every day is different.
Yeah, that's great, Tyler. And we actually dove into my first area, which is I want to get a sense of the composition of the office. And I know that you're relatively new to the Texas AG, same like me, kind of 14 months in. In addition to lawyers, is there also do you also employ technologists, engineers, maybe former compliance? So talk to me a little bit about the actual makeup of that team right now.
Yeah, we have a range of expertise. I think attorneys come from a variety of backgrounds. Some like served as chief privacy officers like yourself, some in-house roles, litigation backgrounds, enforcement backgrounds, regulatory backgrounds. It's a really broad mix, which I think sort of from the practical standpoint of like a new team enforcing new laws, you do a lot of thinking on like what expertise you're going to need in order to sort of be successful. Same with support staff. We have our office was lucky in that it had some technologists already, or I guess I would say tech oriented folks, but they came over. We've hired some new ones as well. The Texas law also required sort of the creation of a new privacy related complaint database, but that's like monitored by both our like privacy analysts and support staff, and they're always doing analysis on like the number of complaints, what type of complaint, if it's related to what right it relates to, and things sort of like that. So there's a lot happening in the background every single day.
Yeah, here seems incredibly well resourced. I mean, coming from in-house kind of industry, we're lucky from an operational perspective if we get one person addressing privacy. So the number of folks that are at the Texas State AG with the variety of backgrounds seems pretty mature. From your perspective, does that kind of align with what you're seeing with other state AGs that are having their own privacy functions as well, or?
Sure. So, yeah, really important question as we see more and more states with privacy laws on the books that they will be enforcing. The natural question is who is going to be enforcing those laws? And looking across the states, it's certainly the case that when we are talking about new consumer privacy statutes, it is typically exclusively the government regulators who will be enforcing those new laws. There are two maybe odd ones out, Washington State and Virginia. Both have new consumer health data privacy laws, which are enforceable through private rights of action tied to those states' existing consumer protection acts. However, typically we're talking about government regulators. When it comes to those state enforcers, the odd state out here is probably California. First state to pass a privacy law, the CCPA, back in 2018. In 2020, they passed the California Privacy Rights Act ballot initiative, expanding that law and setting up the United States' first privacy-only government regulator, the California Privacy Protection Agency. That's very much an ongoing process, I would say. One of the former executive director of the California Privacy Protection Agency said, we're building the car as we're driving it. It's an agency charged with enforcing the statute, writing rules to interpret the statute, as well as doing things like filing the proper paperwork in order to buy printers. So the alternative to California, of course, is to vest enforcement authority with the state attorney general office. And these are typically very well-established professional officers who are already the consumer protection cops on the beat. And so when it comes to attorney general enforcement of new state-level consumer privacy laws, we are increasingly seeing these states stand up new departments or units dedicated to consumer privacy issues within those broader offices. So I would say that very much aligns with the approach that Texas has taken. I hear 20 full-time employees in Texas with that unit certainly seems large for a dedicated privacy enforcement unit at the state level. But also, not surprising, Texas is obviously very large, very big population, a home to much industry, a wealthy state, and also has a number of privacy laws to enforce, more than we have in various other states. From where I sit, it's actually not always obvious how many full-time staff are enforcing a state privacy law in any individual state. As another example, though, I will point to Oregon, which recently issued a 6-month enforcement report of actions taken to its newly effective comprehensive consumer privacy law. And it revealed that its privacy unit within the Oregon State Attorney General Office is currently composed of 2 assistant attorney generals and is actively recruiting for a third, 1 policy analyst, and a technology-oriented research analyst who works full-time on privacy and data security matters. So I would guess with most of the states, that is probably more the size of the dedicated privacy unit that you would get compared to a larger state such as Texas or such as California. But, I think it varies. I watch a whole bunch of committee hearings on different privacy proposals. And this year, there was one state attorney general's office out there with a privacy law coming into effect soon, out there testifying, look, we're only going to have 1 person on staff to enforce this law, and arguing that the state lawmakers need to find additional mechanisms to fund that state attorney general's office to enforce their privacy laws. And there are some different approaches that some states are taking for how are they going to staff up the regulators for these privacy laws. And it's not always obvious from the bills themselves. You have to go looking at attached fiscal notes or go into a separate massive 1,000-page budget proposal to try to figure out if any specific funding has been allocated. And certainly sometimes that happens through budget bills, or sometimes these laws provide that some amount of settlement monies recovered from enforcement actions can actually be used to go back in and fund the regulators. And that's the approach Virginia took with its Consumer Privacy Fund. So there's various approaches to how states are seeking to bulk up the enforcement arms and staff to with respect to these new consumer privacy laws.
To piggyback off of here, I think that was sort of one of the underreported facets of Texas, was that the legislature, when it passed its privacy law, included a bunch of funding for like a whole new team. So like I think that, to me, just from sort of when I was debating whether to take this role, like that was a very like enticing aspect, right? Because it was a funded team and it wasn't going to be just 1 or 2 attorneys. And I'll also flag, sort of not to tout the Texas model too much, but there's also a lot of advantages of being within like the broader consumer protection division, right? Because like these are established offices that litigate, and so like not only does the privacy and tech team like focus on sort of potential litigation matters, we also have the broader consumer protection team to lean on to like staff that litigation. So it's extremely helpful in that regard.
Super quick follow-up question here. Given the uniqueness of California with the CPPA, do you think there will still be cooperation between the CPPA and the state AG, given we've seen, for example, Attorney General Bonta put out guidance for the 23andMe deletion, not debacle, but kind of guiding California residents to delete their information, which again, seems to me as somewhat of a privacy issue, but any sense of the cooperation that they might be having as well, or?
I certainly would expect there to be cooperation. It is very unique to have a state privacy law here with 2 different regulators. And there are some kind of nuanced differences between each party's authority. At this stage, the Privacy Protection Agency can draft the rules. The AG started with that authority, no longer has it anymore. There's differences in how long each agency has to actually bring an action after the alleged violation occurs, though I know there's been legislature to try to standardize that between the 2 offices. But I'm a guy who goes to a bunch of privacy conferences, and I will often see regulators from the AG's office and the CPPA on stage together at the same time, though what's happening behind those scenes and how those discussions work, I'm obviously not going to be in a position to answer further.
Good. Speaking of other state AGs, Tyler, wanted to better understand the extent to which you might be cooperating with your peers at other states. Are there any other recent examples of multi-state efforts happening? Talk to me about your interaction and engagement with other state AGs focusing on privacy.
Yeah, I think there's a lot of sort of formal and informal engagement that goes on with other state AG's offices. Obviously, the multi-state enforcement process has existed for a long time, which is where, states sort of with a common interest in going after company or a specific type of conduct pair up. In multi-state efforts, there'll usually be an exec committee made up of around 4 states and then several other states that like sign on with sort of the exec states driving the matter forward. There's also, I think historically there have been weekly working groups. I'm sorry, not weekly, monthly working groups around. It used to be more like a cyber focus, but that's sort of changed over time. But even within like the larger cyber working group, there's now separate like privacy or I would call it like a subgroup of privacy folks with states that either have passed privacy laws or states that are that have not gone into effect or ones that are about to go into effect. So there's a lot of like information sharing that sort of goes on with those meetings. And then there's a ton of informal information sharing, whether it's, how, like, what are sort of like best practices or what has our office found success with and like process wise for investigating conduct, or, we might have a press release announcing an investigation into a company. And like, it is rather common, for another state to reach out and ask, hey, what's going on here? We're kind of interested as well. So there's a lot of coordination, and it's kind of fun seeing what like other states are prioritizing. It is overall just a very collaborative process.
Yeah, that's really insightful. And I assume that you probably don't want to recreate the wheel when it comes to some of these resources or maybe areas of focus. But Keir, from your perspective, are you seeing any trends with respect to a multi-state AG coordination? Are they using common frameworks? Talk to me a little bit about your view, given you have that multi-state kind of perspective.
Sure. So I do think Tyler told you better than anything I ever could here. It does seem like there's definitely exchange of information and potentially tactics, both through some kind of formal channels and maybe more informal conversations. Stepping back a step, we are still in a fairly new era of the United States kind of modern approach to consumer privacy protection, which is largely being led and set at the state level. Again, this kind of kicked off in 2018 with California enacting its comprehensive consumer privacy law. We're now up to 19 state privacy laws, but really we're still at something of an early phase in those laws, going from kind of words on the page to frameworks in effect that are being implemented, interpreted, and ultimately enforced. So I think there's still evolution work to be done, both on how states staff up and choose to enforce these new privacy laws, as well as how they work together with each other. And certainly at this stage, we haven't seen any states kind of take joint action to enforce one of these privacy laws at the same time. And I think there may be some kind of structural reasons why that may be the case. These laws go into effect at different times. They have different requirements when it comes to things like offering a right to cure to a company who may have be in violation of some provision under a consumer privacy law. So remains to be seen to what extent we see these regulators kind of begin to work together in that manner. But I will note that there is a long history of multi-state AG coordination when it comes to taking action with respect to privacy harms and unlawful use of personal data. Basically, every state has some sort of a kind of mini FTC Act or law regulating unfair and deceptive acts and practices. These are the UDAP statutes that we talk about all the time. And there is a lot of alignment between those state UDAP laws because basically they're all very short, they're very simple. Don't behave in your business practices in an unfair or deceptive way. Right. And those of us in industry, or those in industry, may hope to see a bit more guidance when it comes to actually building products and deciding whether or not you can use data in a certain way. However, we've seen at both the Federal Trade Commission level and in the states that this UDAP authority can very much be applied to unlawful collection and use of data. And we've seen many multi-state actions in the privacy space based on the state's UDAP authority. And a recent example, 2022, a coalition of 40 state attorneys general offices settled with a large tech company for $391 million regarding allegations of the collection and use of location data. So at this stage, it still seems to me that those types of joint actions between the states are going to be more common and potentially more likely than joint actions pursuant to these new types of laws that we've seen start to take effect following 2018.
I love those UDAP laws. No one's privacy policy is safe under the UDAP laws. Tyler, wanted to kind of get into the meat of things here. There was just a small piece of news that came out of your office a couple months ago, but actually something pretty watershed. Your office had filed lawsuits around the collection and use of geolocation data from consumers without consent, and I think it was brought under both the Texas Deceptive Trade Practices Act, so what Keir had mentioned, and then also obviously your existing Data Privacy and Security Act. I don't call it TDISPA, but I've heard that at a conference. I'd rather say the TDPSA. Tyler, what are your thoughts on that acronym?
That's my preferred acronym as well.
Okay. TDPSA. With the latter, obviously this is the watershed piece that marked the first lawsuit to be filed under a state AG to enforce a comprehensive privacy law. So lots of kind of groundbreaking stuff happening. I wanted to break down that enforcement a little bit. So there was some things that were alleged, violation of a couple things, including the failure to provide clear privacy notices, the failure to disclose the sale of sensitive personal information, to obtain informed consent, the failure to disclose profiling activities and opt-out options. So lots of alleged things happening that, to me, again, from an operational CPO perspective, are table stakes for any mature privacy program. We should be fully transparent. We should be operationalizing proper consent mechanisms. So I wanted to kind of break down some of these alleged practices, Tyler, and maybe first start with this concept of consent. What is actually obtaining proper consent look like in this specific scenario?
Yeah, I mean, I think even taking a step back, our office is mindful that these laws are new, but a lot of the concepts that underlie them are not. So if you look to like the TDPSA's definition of consent, like that's consistent with what Texas courts have always held. I'm pretty sure I think there's Texas Supreme Court precedent that's basically verbatim what the definition of consent of our statute is. So while like these laws are new, a lot of the concepts aren't. And so I think it's important for companies to, kind of be not just aware of sort of that aspect and use that guidance, but also, when particularly with sensitive data, understand your obligations. And so I don't think there's going to ever be one right way to obtain consent. But I think when you're bearing the lead or not indicating the lead at all, I think you will face an uphill battle with our office, and I assume most state AG offices, of convincing them that there was in fact consent. So, I think in one thing we've seen a lot of companies like sort of start to adopt is sort of like use case consent screens. So like if they're wanting, the consumer might have agreed to like have geolocation tracking on, right? But like, are they agreeing for it to be used for specific purposes, which is required under our law? To have meaningful consent, to have actual consent under our law, you have to disclose how you're going to process the personal data. And so, if you want to do sort of a soup to nuts approach, I think more consent screens, or if there's like potentially controversial uses of that data, an additional consent screen is not going to hurt you. And I think sort of, again, taking a step back, like if you can point to something and say like, this is what we did and we thought it was reasonable, like we're happy to make some changes to it. If when you're interacting with our office, I think that's like, we're viewing everything through sort of the lens of reasonableness, right? We're working with tons of companies across sectors, and we're seeing all the different practices that they put in place. And so, we're happy to have that conversation on what you view as reasonable and what changes like we might push you to make. But, at a minimum, there needs to be sort of a good faith effort, I think, to comply with the law and make sure consumers are informed about what you're doing with their sensitive data.
Yeah, I definitely hear you. And from an operational perspective, I've talked to dozens of other CPOs and privacy leaders over the past year. They are really focusing on, trying to build that balance between what product teams want, what executive leadership wants around, certain features, and adhering to the spirit of, respecting consumer privacy, whether that be not burying privacy controls in menus. To your point, Tyler, popping up the proper notices and consent mechanisms when sensitive personal information is being collected, for example. Really instituting and honoring this concept of choice. Really great insight from you in terms of like what the state AG is looking at from an operational perspective. Keir, I wanted to get your thoughts a little bit on this definition of consent. Again, seems to me to be pretty, seems to me the definition is what we're seeing in other states as well, but are you seeing any nuances with respect to other state laws with respect to their definition of what proper consent is?
Sure. Really great question. And obviously, consumer consent is a core piece of many of these privacy laws, both in the States, nationally, and in many cases globally as well. So by my count, there are 19 what I would consider comprehensive, broad state privacy laws. 16 of them require opt-in consent if a business or sometimes a covered nonprofit seeks to collect, use, or share sensitive data. There's definitely a lot of nuances between the states on what personal information may or may not be sensitive data, but you can be pretty sure that precise geolocation data is going to be recognized as a form of sensitive data in every one of these jurisdictions. And the requirements on the page for what constitutes valid consent is very consistent here across these states. That opt-in consent has to be freely given, specific, informed, and unambiguous. And I think those qualifiers certainly matter. However, at this stage, and this is something I think I've harped on many times and will probably harp on in every answer I provide here, we are still in early days of enforcement of this new kind of formal state level consumer privacy laws. And there's not necessarily been a great amount of guidance on enforcement actions that really provide some additional concrete examples of what mechanisms may qualify as valid opt-in consent or not. Texas, obviously a first mover here. This is the first litigation under one of these comprehensive consumer privacy laws. I think there's a lot to learn from the filings and allegations here involving how the Texas AG's office is considering what valid opt-in consent requires. And it's also, tremendously helpful for Tyler to share that, the office also looked at what consent has historically meant and been interpreted as involving in the state of Texas in other contexts, potentially outside of the privacy space. And of course, those who know that freely given, specific, and informed, and unambiguous element of opt-in consent in the European Union with the General Data Protection Regulation. Definitely a whole lot of guidance there from groups like the Article 29 Working Party and such, and what opt-in consent entails. But to what extent will that necessarily transfer over to the United States? I think potentially in question a little bit. In terms of other jurisdictions and where there may be some nuances with respect to consent, California actually doesn't have a strict opt-in consent regime for sensitive data processing, collection, use, but it is one of only 3 states with explicit rulemaking authority and under its Privacy Act, and California tends to get very, very prescriptive in its regulations. I think we're up to about 150 pages of final and draft regulations outside California, and we know that that state is thinking in a very prescriptive way about user interface design of cookie choices. And I think that was demonstrated out of California with this California Privacy Protection Agency's recent settlement with Honda, where the agency really laid out they expect the number of clicks to opt in versus opt out of certain cookie settings has to be exactly the same number of clicks for an individual. We also saw the New York Attorney General's office also issue kind of similar guidance about user interface design with respect to cookie choices pursuant to its UDAP authority, actually. And New York is one of the states without a comprehensive consumer privacy law. This is in the comprehensive consumer privacy space, but consent is getting a little bit more complicated when it comes to some of these sectoral privacy laws, particularly thinking about some of these health privacy laws. Washington State has the My Health, My Data Act. It introduced a heightened tier of consent called valid authorization for certain sales of a very broad range of covered health data. And I think some very more procedural and prescriptive to try to meet that valid authorization standard in Washington State. A bill to amend the Minnesota Privacy Act was recently introduced, which would borrow those concepts of valid authorization. The New York State Legislature has passed a health privacy law, We're waiting for the governor's office to call that bill to her desk, so it's not final yet, and there may be an opportunity for chapter amendments, but it also has this concept of valid authorization, which in some ways is even more prescriptive than Washington State, and actually says you cannot actually obtain that level of consent until 24 hours after a customer or a potential customer originally interacts with your business. So I think a lot of questions there about how that could be operationalized in practice. So big picture, a lot of conformity in the existing state laws about what the statutory requirements for valid consent requires. But certainly if you're working in a business in this state, pay very close attention if states start increasingly adopting different standards here. And I think you mentioned the patchwork at the beginning, Ron. This is one of those issues where the patchwork could very soon get a fair bit patchier.
Love that. I think everyone is waiting with breath that is bated on NY HIPAA. A couple of other points that I took from you, and especially for the operational folks here, if you don't have an accept all, if you have an accept all, you better have a reject all. So yeah, lots of great tidbits there from you, Keir, from a state by state perspective. Tyler, I wanted to quickly go back to that enforcement and take a bit of a macro view. I was wondering, could you provide a little bit of could you share anything about how your office might be identifying targets for enforcement? Are they more complaint driven? Are you using more industry monitoring or cooperation with other states? Kind of talk, can you give some insights on that?
Yeah, I think there's sort of a variety of ways. We have, our specific privacy complaint database, that tends to be a little bit more about whether someone can exercise a right. I always think back to sort of one of my favorite anecdotes of this job. Our law took effect on July 1, 2024. And on the first day, we had around 10 consumer complaints, with the majority complaining about consumers complaining about whether they could exercise their various rights at fast food chains. And it was different consumers from all across the state. And I just found it was not on my bingo card. And so that is sort of one mechanism. I think yes, sometimes, we hear about things from other states or potentially the FTC. And then, also like anything that's sort of in the news, that is also comes to our attention pretty regularly. And then just a reminder that like everyone in our office is also a consumer, but they're also like somewhat sophisticated consumers. So they're it's not uncommon for, an attorney or a privacy analyst in our office to say like, oh, I've been using this app and like I went to their privacy policy and it clearly does not comply with the law. Like you'd be shocked at how many of those, how that is the catalyst for an investigation kicking off. And so I think those are the sort of the main ones. But at the end of the day, we're consumers too. So I think all those state AGs sort of share that same sentiment.
Yeah, I think the practical guidance there is make sure that someone's monitoring your privacy at mailbox for some of these things. I actually, this is a great segue, Tyler, into a lot of the practical guidance that I want to glean from you, especially when it comes to companies that engage with regulators. Can you give me a little bit of insight into how if I'm being, potentially investigated, or, you might be calling my team up for more information, what's the best way to interact with your team? Any tips or guidance you can provide for folks, CPOs that are potentially maybe under investigation, or, that maybe just want to engage with your office proactively?
I think we've seen a variety of approaches. I do not think anyone at any level of this office will be upset for sort of a proactive outreach, whether that's because a breach hasn't gone public yet, or you're rolling out like a new AI product that might, hit the news and be kind of viewed with like a controversial lens. Like no one here will ever fault you for that. And I think it shows a lot of good faith that could be helpful later on by reaching out early, by starting a conversation. And, from sort of like my seat, it's always helpful if you have done that, because if you make it in the news and our front office reaches out, wanting to know what the heck is going on, I can say, oh yeah, well, they've reached out, we were aware of it. This is what we're thinking. This is what we like. This is what we don't like. I think it goes a long way to show some good faith there. Sort of on like once an investigation is kicked off, it can kind of vary depending on sort of the scope. So, if it's just a violation notice from under the TDPSA, those are a little narrower in scope. But I think it's important, and this sort of gets into the maybe the sort of the misstep or missteps that can happen, but never assume we don't know anything before we contact you. Oftentimes, like, a lot of our investigations overlap into different companies, or like you're a counterparty with someone who's a counterparty with another person, so we have some insight into like what your practices are. So we come at a lot of these things with like sort of specific knowledge about what your practices are. So I think I always encourage people to make sure that they are accurately representing sort of what's going on. But even with like the smallest investigations, I think engage early, engage often, ask questions. I mean, those are the sort of outside counsel that are the most successful, are the ones that ask a lot of questions. We can't always answer them, but we try to be as forthcoming as possible. And so, I think it's good to like not leave anything on the table that would help you in responding to an investigation by just not asking questions. It always helps to ask things, whether it's like what's driving it, what you've seen, how big of a priority, those are all like fair questions to ask that we try to answer as best we can.
That's really helpful guidance, Tyler. I think the fear from the operational side is once we might show you, like, maybe there's this new feature that we're working on, or something that we want to push out to consumers that we've identified as a little bit risky, that we're now on your radar. So I guess it's that fear of showing too much, or, but hearing that from your perspective around, you obviously have a team of experts. You have tech folks that might be able to work with our product and engineering folks and give a little bit of insight. I think that's really helpful. Here, any insight you want to add here in terms of what maybe as operational professionals we could expect working with other state AGs above and beyond Tyler's?
So, big picture, we've talked about the patchwork here a bit, and the patchwork is certainly real. But at this stage in the state privacy law landscape, I think there is far more alignment between different state privacy regimes than many may have feared would develop back in 2018 when California became the first mover. And most organizations that I talk to still feel like they can build kind of a one-size-fits-all compliance program that encompasses these different state privacy regimes. Though we will also see what happens when Maryland's unique in some very significant ways privacy law takes effect later this year. However, at the same time, in my view, there is no one state that you can build out your compliance program to meet that will ensure compliance with the privacy laws in all the other states. And when it comes to conversations with the regulators in those different states, those unique differences certainly matter. Kind of bring it back to Texas. Texas has or passed its privacy law with novel disclosure requirements. Not all kind of information necessarily had to be contained in a privacy policy, but businesses, if they're engaged in certain sales of sensitive data or use of biometric data, have to make more prominent privacy disclosures than other state laws are required. And in some of the activity we've seen out of Texas, they are definitely interested in ensuring that statutory provision of their law is enforced if you're a business covered by that Texas law. And I called it unique, but actually Nebraska thought that was a really good idea and replicated that in its privacy law. So that's a requirement in 2 states these days, I believe. So be aware of the full kind of landscape of obligations that your business may face. When it comes to engagement with the regulators, I think certainly take those communications seriously. These are real laws. They have real teeth. And in many cases, they may require changes in business practices that at times may be uncomfortable. I have a lot of sympathy with the privacy professional and know that privacy officers aren't always the biggest priority in some, though certainly not all companies, but we are increasingly seeing enforcement actions, and those enforcement actions should be pointed to as a reason that an entire business needs to take these statutory requirements very seriously. And I will just close on one point. Many of these laws still have what is called a right to cure period. And in some cases, that's a mandatory right to cure period. If a regulator suspects that your business may be out of compliance with a privacy law in some capacity, you may have a statutory right to be able to take actions to rectify that alleged violation that will close the matter before a formal enforcement action may begin. Though in many cases, you may not have much time to take advantage of that right to cure period. It may only be 30 days. It may only be 45 days. So if a right to cure notice comes in and there's an ability for your business to take advantage of that opportunity and cure the alleged violation, you do not want to be stonewalling. You do not want to be dragging your feet. It is very important to take those notices seriously and act if you can within that right to cure window.
Glad you brought up that right to cure piece, Kira, because a couple questions have come in, and maybe Tyler, I'll start with you in terms of, I know that the TDPSA is currently in this right to cure period. I'm wondering how your office is approaching this regulatory window and some guidance for companies that might be kind of just thinking about that.
Yeah, I think sort of to Kier's point with the patchwork, we are viewing everything sort of through the lens of reasonableness. So, which is consistent with the legislative history of the TDPSA, which I think very correctly acknowledges that there's going to be a patchwork. And so there's guidance within the legislative history of the TDPSA that like if there's like conflicting provisions, like give deference to that. So, whenever we're engaging with companies, we're mainly looking for whether the steps you took were reasonable. So if you tell me like, oh, we did this because it complies with California, like that is great. Like we're happy to sort of cede our, maybe not happy, but we're willing to cede, your practice to another state. So we're not trying to sort of needle people on the nitty gritty of, what word choice you used in your privacy notice. We're more looking for like complying with the spirit of the law, I would say. When the cure period happens, once you receive a notice, I think ours is 30 days. 30 days goes fast, to be clear, but while we're always, maybe not always, but we're willing to give people, as long as they're communicating with us, showing us there's a plan to get like these changes in place quickly, or at least in a reasonable amount of time. If 30 days passes, we're not necessarily going to escalate this into like a full-blown enforcement or litigation action. But that said, communication is key, because if we know that you're working on this and like trying to get it, but maybe you can't get it operationalized, within those 30 days, you need another 30 to actually do it, like communicate that to us, because we're willing to work with you on that pretty much all the time. I think we're real people too. We try to take a practical approach to all of this. But, the worst thing you could do is like sort of ignore, like dispute whether notice is sufficient or things like that. Cause like, again, just have a conversation. We're learning on the fly somewhat as well. But I think it's important to, if you see like we got something wrong, reach out. Conversation, a normal conversation about it. Like this, we're always happy to engage with companies.
I'm definitely no stranger to regulatory scrutiny. I think at one point, EU DPAs had my cell number and their speed dial, but this is really great information. There was one question here in the question list that was a little bit specific, but wonder if you have any insight on available statistics or information from the California Privacy Protection Agency or AG's offices on companies utilizing this actual right to cure. Any insight there on statistics that would be helpful here?
Yes, so in California, the right to cure period existed when it was the state attorney general's office that was the sole enforcer of the CCPA of 2018 at that time. That office was, I think, very vocal about how much they appreciated that mechanism within its privacy law and released a lot of information online. I think it's still available on the California Attorney General's website of examples of the right to cure period being used in California. Names redacted, obviously, so pseudonymous examples potentially, but it revealed the nature of alleged violations and steps that different companies had taken to come into compliance. The other two states I would definitely look at for information on how this right to cure period is being used are both Connecticut and Oregon, which each released, I believe, 6-month enforcement reports for the first 6 months of state AG activity after their state privacy laws took effect. And that details a lot of information about use of the right to cure period in those states, including information, kind of what were the alleged violations, kind of how many kind of cases, I guess, in how many different categories. And then one other, I think, interesting piece in the broader right to cure conversation worth considering is that the right to cure is sometimes, I think, negatively referred to as kind of a potential get out of jail free card. However, I think we've seen that not every enforcement authority is going to think that a right to cure is always going to be possible in every case. And the California Attorney General brought an action against DoorDash, and they kind of alleged that the nature of the violations was such, personal data had been shared to third parties and then maybe potentially shared beyond that, that right to cure may actually not have been possible in that circumstance. The toothpaste may be out of the tube, so to speak. So that is something we've seen, and I will say we've seen that in this one California settlement, but also something to pay attention to in the broader use of the right to cure by different state regulators in this space.
Amazing. Thanks, Keir. I wanted to end the webinar on, I mean, I don't think we can talk about US state privacy law without talking about the lack of a federal privacy law. Obviously, failure of APRA, we still, as operational professionals, have 19 or 20 state laws and their nuances to address on a day-to-day basis. And again, something that I'm hearing from the CPO community is, that there is a want for a federal standard. And again, also thinking about the potential patchwork, to your point of AI regulation that might be coming down the pipe. Maybe not with this administration, but just the sense of like this never ending rat race of trying to comply with every state's requirements. So Tyler, just kind of question for you when it comes to this federal framework, wondering how you think a state law like the Texas TDPSA might play into that. Are there any components in your existing state law that you're like really gung-ho must be in a federal law? Kind of talk to me about your thoughts around the potential or anticipated, not APRA 3.0 or whatever it is, but an anticipated federal law that, again, as operational professionals, we're anticipating and excited for.
Yes, this is truly in my personal capacity, truly in my personal capacity. I think sort of what I've been hearing is that the Texas and Kentucky type laws are in the lead or are the betting favorites if a law does in fact pass, which that is impossible to predict. I think our law does a really good job of sort of realizing that like this is new territory as far as regulations go and regulating the specific type of conduct. It draws a good line at sort of what are like the facial fixes, which are pretty easy to fix in 30 days versus what are potentially some more harmful practices, and by extension, harder if not near impossible to cure. So things related to profiling, selling of sensitive data. It does a good job of sort of drawing that line. And I think several states' laws all draw similar lines. And so I think that's sort of where I always think of when companies are trying to comply, like it encourages them to sort of think exactly like that. What if in a regulator's eyes would be viewed as more harmful, and treat that as carefully as possible. And like the other things, you can at least like, I think that's where we take, the more reasonableness standard. We're not going to needle people on things. So, I hope but cannot predict that a federal law matches ours or is relatively similar to ours in the end, but we'll see.
Thanks for that, Tyler. Here, I can't wait to ask you this question, but a couple IPPs ago, I was at this panel where we had, really the cream of the crop in terms of CPOs and their predictions around APRA, either passing or a federal standard, coming into play. And a lot of folks were saying, we're going to see it next year, or this is definitely going to pass. Obviously not the case or the feeling now. Wondering from your perspective, given you have such a broad lens here, maybe predictions on when we might see one, and then also what you think a federal law is going to need to have, given what Tyler had just mentioned around, maybe the TDPSA being a front runner?
Sure. So let me just lead off by saying it would absolutely be appropriate to pass a federal privacy law in this country. The United States is now kind of the only G20 nation without a kind of national approach to consumer privacy rights and protections. Take me, for example, I live in Washington, D.C. I'm a jogger. I can go 3 miles south and I'm in Virginia, which has a privacy framework. I can jog 3 miles north and I'm in Maryland, which has a totally different privacy framework. I can sit on my couch and drink chocolate milk to recover and be protected by basically no privacy rights. That's no way to run a country. That's not good for consumers. That's not good for businesses. I don't want businesses trying to figure out if my residency is DC versus Maryland versus Virginia. So will we get a federal privacy law? Well, there was certainly bipartisan efforts around the ADPPA and APRA in past Congresses, and a lot of people think we came very close with those laws. I agree with them. I think Team Privacy had the ball, we had the momentum, we were driving downfield, and we got all the way down to the 5-yard line, which means we only had 95 more yards to go. We did not come that close. And I think a reason we did not come that close is because those two frameworks, we talk about ADPA and APRA the whole time, but they were actually rooted in federal models that exist actually as far back as 2019. Folks in the space for a while will remember COPRA. They'll remember the Safe Data Act. And the landscape has moved a long way since 2019. California had just passed. It had not yet taken effect, but now we have 19, 20 or so state privacy laws. Many of them are actually in effect. They're being enforced. Businesses have built out their compliance operations. Consumers are exercising and enjoying their rights. So I think we're in an opportunity and moment where it would be appropriate for a federal reset on these efforts. And I think a good place to look would be at what is happening in the states. We talk about the patchwork, but also 16 or so of these 19 state-level privacy laws all adhere to the same general framework. I think that framework would be a good place for federal lawmakers to start in considering what an appropriate national privacy law would be. In some places, maybe protections or requirements could be tuned up. In other cases, maybe could be tuned down to support a data-driven innovation, a data sharing for research, etc. But I certainly think that's the place to start. And I am motivated by recent kind of conversations on the Hill that policymakers and their staffers are still taking this as a very serious issue and very serious need and looking at states such as Texas.
Wonderful. Keir and Tyler, I am so incredibly honored that you provided your time here today. I know you guys are both incredibly busy, and I cannot wait to see both of you at the IPP in DC in about just 2 weeks, I think. Small plug for Transcend. We are the title sponsor of the IPP this year. Come visit us at our booth. And I will pass it over to Andrew Moon to wrap things up.
Thanks, Ron, and thanks everyone for joining today. Just for some quick housekeeping, make sure you're following the Future Privacy Forum and Transcend on LinkedIn. And a quick bit of promo, as Ron kind of alluded to there, we have the Transcend booth at DC at Global Privacy Summit. There's also the Defining Privacy After Party on the Wednesday night. But we're also a sponsor as Transcend of the FPF's annual Spring Social, which is on Tuesday night. It's after that kind of first opening of the exhibit hall and the conference. It's going to be a fantastic networking event. Tickets are free too, but they are going fast. So if you want to register for that, just Google FPF Annual Spring Social and make sure you register. I would probably say this week to make sure you don't miss out. But with that, thanks again. Thanks for joining us and enjoy the rest of your day.